It is the home of the amazing things. It's the home of limitless potential. A place where barriers are broken. The home of no-holds-barred discussions.
The sex and color. and we feel nothing for health.
It is the home of surprises. And DJ Mix, the only home of the superstars. 10 over 10. With the sizzling Joy Muzengi and the wild Willis Raburu. Catch this electrifying show every Friday at 10 p.m. only on Citizen Television.
Yes, welcome back, and this time for real. Good morning, my name is Freddy Ndimuli. This is Citizen TV, watching the Power Breakfast. It's time for us to take a look at the headlines this morning. The big one, of course, Raila Odinga going to court. And that's a big headline on the Standard. It's now in the hands of the 7 judges, and we're talking about the judges of the Supreme Court. 6 pillars of Raila election petition. That's the headline on the Daily Nation. This morning, a privilege to have Charles Munyui as my only panelist for this news review. But we'll be joined also by Sandra Ochola and hopefully Charles Kipkule as we go along with the news review. Good morning, Charles. Karibu sana.
Good morning.
Yes. Now, of course, the big one, and probably we could come back to this a bit later on. The other very interesting headlines, of course, is the state holding the clampdown on lobby groups and civil societies. Fred Matiang'i stepped in and suspended the purge on Africog and KHRC yesterday. It will take a process now. A committee has been set up to actually look into the issues. But the other big headline, and this is what everyone is talking about, Matiba wins 500 million court award. That's a story on the back page of the Daily Nation. And for the sake of the younger viewers who may not know exactly who Kenneth Matiba is, let me read probably the first 2 paragraphs of this story. Veteran politician and multi-party democracy crusader Kenneth Matiba has been awarded 504 million shillings for his detention. Although the 85-year-old former Kiharu MP will not regain his health, Justice Isaac Lenaola said the award should act as a reminder of the dark days of the Nyayo era. Now, Matiba was a founder member of the opposition party Ford that later split into Ford Kenya and Ford Asili. While he led the latter faction, that is Ford Asili, Jaramogi Oginga Odinga, the late father of ODM leader Raila Odinga, steered the other. Charles Munyui, of course, you were well versed with this political history, and probably just to explain and paint a picture of how important Kenneth Matiba was and how that issue turned out, so that probably, because most of our viewers, our younger viewers, people born in the 90s, do not really understand who Kenneth Matiba is and how big this court decision is.
Kenneth Matiba, amazing. This gentleman was amazing. In fact, for some strange reason, he never became president, but there was a time everyone believed this gentleman was going to be the president of the Republic of Kenya. He was articulate and clean-hearted, and matters corruption and all those things were not things that you would go to bed with. And it's really sad that he ended up being sickly, courtesy of being held in custody and actually getting jailed and seriously getting harassed during those days of the former president Moi. And it's good that he has been able to get this kind of reparation. It might not be good enough. It might not be, because a lot of years were wasted also by him. I can imagine the agony the family has gone through. A breadwinner, a pillar in the home, and now an old gentleman that is sickly and not getting requisite recognition even by the state. And I think these are individuals that we should not forget that easily, that quickly. This award might not be sufficient, if you ask me, but I think it goes a long way also to show Kenyans and the world in general that there is recognition that this gentleman suffered at the hands of because due to politics, bad politics as it were, And moving forward, this should never happen.
Yes.
This should never happen to any one of us.
And happening at this time when we are very much talking about the elections, the disputed election results, us going to court. Matiba actually went through something similar. He disputed the election results of, was it back in 1992?
Yes. And I think it tells you that we have moved quite a number of steps also, and especially in the area of the judiciary, because even Matiba going to court then, it did not really resolve a lot of issues. Now we have a judiciary that, given an opportunity, and especially the Supreme Court that is there with the original and exclusive jurisdiction to deal with presidential elections, and within a very short timeline that is not controlled by anybody, it is there as a constitutional provision. I think now we are better off. If Matiba of then was Matiba of today, there's a likelihood the determination that was made then would have been slightly a lot different right now with the judiciary that is there.
Yes. We've also joined on set by Sandra Ochola. Karibu sana. Traffic is back in Nairobi, I'm sure.
Clearly.
We've decided to start with this headline about the court award to Matiba, 504 million shillings, and this is big news, but most of our younger viewers may not really understand how big or why relevant this is. Yes.
I believe it is quite relevant, and because we always say that your history, it's important for you to know where you are coming from in order for you to know where you are heading to. And I believe airing of such stories, discussing such things in one way or another, they inform the younger generations and keeps them aware of where the country has come from in terms of civil and political rights. Whereas an individual, we have the right to make political choices, to multipartism, for you to belong to a party and form a political party without fear or favor, or without fear of victimization. So I think it's good, and I think for the younger people, it's from a place of appreciating the roles that those who went before us have made for us to enjoy the kind of freedoms and rights that we're enjoying today. Yeah.
Yes, multi-party democracy is something that we are really enjoying, as Sandra Ochola says. The days when even his agitation just for multi-party democracy is what led him to lose all he had. And very many young people who have gotten to vote for the very first time, this time round, do not understand how bad it was back then.
They don't. They don't. And I wish they would wake up very early in the morning and go and vote, and without even being pushed. I wish they would pursue the aspect of registering as voters, getting IDs in good time, with the objective of voting, because Matiba was about those things. And if you remember how hard it was to even belong to any other political party other than
he was jailed simply because you opposed to the president.
Exactly.
This time you can actually rise on a podium and actually tell the president whatever you feel like.
And everyone is trying to be president on all manner of political parties, and especially the aspect of being an independent candidate. Forget about now even forming a political party. Just waking up in the morning and say, I don't believe in any political party, I will not pursue that line of forming a political party or joining one. I just go in there as an independent and I'll seek that elective positions. We've seen that happening. We've seen individuals that have were not known a few days earlier joining the race and actually becoming contenders, being invited for national debate and all that. I think these are the steps that we've come to, the courtesy of a gentleman like this one and others that suffered with him. And it's sad that our history is such that we don't talk about individuals like these ones.
And there's a paragraph here, probably I could just read for the benefit of our viewers. When they began agitating for multi-party democracy with Mr. Charles Rubia, they were arrested and detained. It was that simple.
Yes.
You agitate for some political space, some political freedom, you are arrested and detained. And in his ruling, Justice Lenaola of the Supreme Court noted that Matiba suffered a stroke on May 26, 1991 while in detention, but remained in detention without medication for a week. Yes? Hence this award. Yes. You wanted to add something?
Wow. Those are sad stories to read, but again, very educative. And for me, I always ask, why aren't we keeping these conversations alive? for the benefit of those who went through this, those atrocities, and also for the generations coming up, so that it's not discussions that they're only going to learn about this morning and through newspapers. These are things that are within their curriculum. These are things that are within their day-to-day political interaction, so that as young people, you know where you are coming from and where you are heading to, and the role that individuals and institutions have played to get you to where you are today. So I think it's important for us moving forward, cross-generational discussions to ensure that these conversations are kept alive for future purposes. Yes,
now in an audit of the empire that Matiba owned back then, it showed that he lost more than 2 billion shillings in commercial real estate, 2 billion shillings in privately held shares, and over 300 million shillings in publicly trading shares, as well as over 200 million in dividends. Now, there's a real cost to the kind of freedom we are enjoying now. There are people who actually sacrificed a lot. Despite the court ruling, this cannot return his health. It cannot return his property, because the kind of losses, this one does not even go anywhere. It does not even start to cover what he lost. And this is just one gentleman. There are quite a number of people who have paid a price for the kind of democracy we get to enjoy now.
That is true. If you notice what the newspaper is saying, that he was managing his businesses personally, and that is why he felt aggrieved, because as a result of being detained, he could not be able to manage that business, and that's why the empire collapsed in the first instance, because he was not there to keep an eye on his business, to run it the way he knows how, and to sustain it where it was. And it was there because of his personal attention to it and working on it personally. So yeah, it is true. A lot of people have sacrificed for us to be where we are. And like my sister says, the best way is, number one, not to forget them. We always talk about this in our good people when they pass away. We should be able to remember Matiba. We should be able to consistently remind our children about Matiba, who Matiba is, by way of having him in our history books. Now, when he's alive, he doesn't have to go anywhere. And more importantly, reparation of this nature is a good sign. And I think it should go across the board. Anybody who was aggrieved in this way should have sought legal redress, because I think it is important.
Yes, there are those who argue that yes, the courts may make such a ruling, but the state is usually very reluctant to actually comply with such an order, and it may take quite some years for the state to pay. Remember, this gentleman is 85 years old. Is it something that can be pushed, so that is it something that even the current administration would want to be seen to expedite?
I believe it will be good, and of course, just like you said, there are so many stories of individuals who've been awarded certain amounts by court, but then they take a long time for them to get their dues, and there's a lot of bureaucracy as well. So I think besides streamlining the process and ensuring that from an institutional perspective, then these bureaucracies are removed, not only for him but for the benefit of or any other person who might go to court later on to seek redress. But then under such circumstances, I want to believe that even at a family level, there are certain systems and structures that have come up to help the old man have better days in his sunset years.
Yes. Is there any political mileage to be gained by fast-tracking this payment to Matiba? Because of course politicians, including the ones who are leading this country right now, are looking to leave a legacy. Is it something that they could do, probably fast-track it?
Yeah, if they did, of course it would look good. And don't forget, our leaders are where they are because of the likes of Matiba. So much as there is also political benefit out of fast-tracking the process of releasing this to him, I think it's also fair. It's fair. It only touches the heart for a lot of people, a lot of individuals in this country, if you don't seem to be antagonizing this particular award by way of blocking, or by way of blocking or slowing down the speed at which you expedite this particular order. I think by so doing, you'll have told Kenyans, because this is public money. It is our money, and we are sitting here, and a lot of people out there are sitting there saying this gentleman deserves this kind of money. Restorative justice, reparation, very, very important. So it should be expedited.
Yes. Matiba awarded 500 million shillings by court. The former minister suffered a stroke in detention, ruining his health and business empire. It is one of those nice stories to read. And it's highlighted on the front page of the Daily Nation. It's there on the back page of the Daily Nation, and on the Standard the story is on the inside pages. And I'm sure, especially for the younger voters, it would be nice to go back and find out exactly what Matiba did. And there's a picture on page 12 of the Standard of a younger Matiba, Kenneth Matiba, arriving from London in May 1992. This was after detention. This was during the campaigns for election back in 1992. The very first multi-party, the very first election under the multi-party system. Before then, it was one-party rule and the Mlolongo system of voting. Very interesting, because that Mlolongo system is what Mr. Matiba and the then President Daniel Moi differed on, because he was defeated through that system during voting. He was a cabinet minister and a member of parliament. Of course, the biggest headline today has to do with NASA's decision and announcement yesterday to go to court to challenge the presidential election results. It is now in the hands of these 7 judges. Raila opts to petition IEBC's results, but leaves his options for protests and labor strikes open, saying they're constitutional. Kenyans now have 14 days to wait for hearing and ruling. And it's very interesting, if my director could help me with this, because this now changes quite a bit of the timelines. We expected, of course, the president to be sworn in on 29th, but with this petition, which has to be filed between today and tomorrow, tomorrow being the last day, the 7th day after the president was declared winner, this changes a lot. And if we could see that story by Francis Gashuri with regard to the timelines, given this decision by NASA, so that the discussion can move on from there. I do understand my director is not ready with that story. We'll come back to that. But a big decision by NASA. Did you expect this one, Charles?
Yeah, I think it's the only way they had. That's the only solution they had.
They had indicated they would not go to court. So no one expected that this was going to be the announcement yesterday.
And I think there has been a lot of contradictions if you look at it critically. A lot of things have been said. A lot of hype has gone around NASA, only to come to the reality that it can only be done in a certain way, in a legal way. And I think the problem is not even going to court. The problem is hyping your supporters to expect something bigger than going to court. And along the way also indicating and saying going to court is not an option, honestly, and then you end up in court. I think this was a good decision on the face of it. In reality, it is actually the best decision ever. What I would have a problem with is talk around it, to the extent that you're telling a court they have an opportunity, or the court has an opportunity to redeem itself. I think that talk is not necessary, because counsel here is here. She'll tell you, you go to court with facts and points of law, and the law. It is that simple, and facts. If you go there, it's not about the rallies that you're holding, because now you're telling Jubilee also to start having their own conversation out there with their supporters to sort of act as if you are intimidating the court. And this is the Supreme Court. They have very little time. In fact, if I was advising NASA, I would tell them, go to that court with specifics and don't go with a lot of information that is not helping you in as far as this particular issue is concerned. So going to court is a good option, but along with that, this should also help the supporters, especially there are those supporters that would stop at nothing, that are just waiting with bated breath. Others are, of course, functioning properly, working, and not. They should help their supporters to go back to their normal lives, show them the timelines, let that determination happen in court, and then from that point on, be prepared to either lose in court or win in court. Because that is critically very important also. Going to court is not everything. The determination by the court is also critical in as far as their supporters are concerned, and even themselves. Yes.
But there are those who feel that it's sort of an anticlimax, because people expected quite a big announcement. No one was sure what it was going to be. But do you feel like it was an anticlimax of sorts?
It's hard to tell at this point, because it's been a roller coaster of emotions, up and down, and a lot of uncertainty. And what I'm happy about is that we are finally going back to this level. I want to call it a level of sobriety, where now we can have conversations without emotions, conversations without a lot of tension. And I'm hoping this is the kind of spirit we'll continue in. For us, I think the conversations about what options it has or had has been an issue of discussion for ever since we had the election. The first option for it was to concede defeat, of which its principals, I think, talked about it and said that is something they wouldn't want to, that's a route they wouldn't want to take, despite the many sentiments from regional, national, even at the national level, for them to concede defeat. The second option was to continue having, letting this play out in the public domain with its own challenges, because just like we've said, there's a human aspect of it, and at some level people get tired, emotions get overstretched, and people want to get on with their lives. So I think the court option, as they have been advised severally, was the best. And this is keeping in mind with the fact that NASA is one of the groups that has for a long time, before we went to the election period, really took its time in court. It had a number of cases that it took to court, and this in one way developed our election. And also, given the personalities behind they are going to court, these are individuals who were in the forefront in the fight for a new constitution. And within that constitution, in its chapter on the judiciary, it outlines what should happen after an election period, so that once the IBC is done with what it does, if there are any other issues that arise from an election, the next stage is to take it to the judiciary, to take it to court. And so what it has done is really commendable, and we hope that moving forward they're going to express the same faith they had in the same faith they had in the judiciary pre the election, so that we are able to bring this to a credible conclusion.
Yes, this is the second election we're having under the new constitution, the second disputed election, a presidential election under the new constitution. There's something to be gained by NASA going to court in as far as precedents in court decisions, precedents in court processes in a case of this magnitude. Definitely, it is not just a useless case.
No, it is not. And the issues they have raised are fundamental issues. They have evidence to support what they are saying. Then it's huge. And you cannot compare what is happening now with what happened 5 years ago or 4.5 years ago. Because I want to believe this is a totally different election, if you ask me. The facts are different. The transmission of results is different. We went into this election with a provision that the results at the polling station are final, and even the chairman of IBC, who happens to be the returning officer for the presidential election, cannot change what is transmitted from the polling station. So I think that was a fundamental issue that will changes this from what was there, because the issue last time was about tallying. Everyone was claiming that the results are back at the polling station. When they ended up here and the chairman was putting them together, a lot of amendments were done. But now, ideally, what we are saying is it's a question of confirming that whatever was done at the polling station is exactly what was received. And if you look at even some of the arguments, you see it follows, and that is the confusion, because from the minute the polling station finalized with the counting, the information was sent, was transmitted, and that was the information that we're receiving consistently from the polling stations. And I think that created a bit of confusion, because everyone expected a whole constituency result to come in, or a whole county result to come in, and then everyone was wondering, how come we have not gotten the Form 34B that comes from the total of all the Form 34As. But without one polling station, then you could not get 34B, because everyone had to wait. And I think that confusion was not properly explained by IBC.
There's been an issue with communication, especially the IBC. But back to this issue of the court processes, and just like it was in 2013, any pronouncement by the Supreme Court has such a finality that I think everyone goes home peacefully, because there's nowhere else you go after that. But there are certain pronouncements made by the judges that change quite a lot, and one of those, from the presidential election petition of 2013, was on whether or not that petition of the presidential election results would affect other elective seats. And in their decision, the Supreme Court appreciated the need for it not to inquire into and decide on matters that are not within its powers, particularly matters relating to the parliamentary, governor, and county elections, which by law are the subject of other courts. Yes, because whichever way this decision goes, there are those who thought, okay, fine, if at all the presidential election results had this problem, then probably even the ones for governors should change. But that is not how it's going to work. No,
that's not how it goes to it will work, because each case will be looked at on its own merit, based on the perception that each election had its own challenges, each election had its own issues, so to speak, especially for those who are going to court at this point. And that, of course, takes us back to an understanding of what the role of the Supreme Court is and why it was established, and particularly for such mitigation or deliberation on election petitions, and also for what do I call it? I don't want to call it translation, but interpretation. Thank you. Interpretation of the Constitution, so that if in the event that it needs to give any opinion as regards to a section of the Constitution, it does that. But then specifically for election petitions, that is what the Supreme Court is supposed to do, and the decisions that is going to give is based on the presidential election petition, so that anyone who has issues later on with any other of the elected seats will go to court on the merit of that particular case, and not based on the presidential election.
Yet some of those issues raised by NASA with regard to the presidential election results, issues to do with, and I'll use Bonarailo Odinga's words, computer-generated results. If at all the courts would rule in their favor, it would mean that even the other candidates who lost in the other elective seats would complain and say, if at all there was a problem in that, then probably the same happened at our level.
The tragedy is that there are timelines, even for parliamentary elections. You can only file the same within a certain period of time, and you must include the evidence that you have and the information that you have. You will not wait for the ruling by the Supreme Court and the judgment to help your case. So I think to a large extent,
so any ruling after 14 days cannot be used in any other,
not necessarily be able to be used for any other elective petition, because of the very nature. First and foremost, there is even a likelihood that the Supreme Court might not necessarily be able to give a judgment within the 14 days. They will just give a ruling. They just say this is the position we've taken, and then I think within 7 days or something, then yes, now they can explain why they took that particular position, because of the tight timelines, 14 days, and we are talking about up to 8 days of basic operational issues. They have so many days to listen to this, to go through this. So it might not necessarily benefit other individuals, but I think more importantly, and if we look at it from a bigger perspective, it will really help Kenyans and even our understanding of the IEBC and the procedures that we are using, and the issues in terms of strengths and weaknesses. This is going to go a very, very long way and tell us, did we really have a proper election, especially the electronic aspect of the same that we have come to seriously trust? Because moving forward, I don't see us going back to where we started, because if this does not work,
we'll keep improving.
We need to keep improving on this. So in the event, for whatever reason, it is proven that the electronic system did not work, then it will have taken us back many steps.
Well, I think the basis of it was the conversations that, and I think I've seen this in social media a lot, that you have other MPs, I think out of solidarity, who perhaps are being cajoled or being asked, why don't you join the bandwagon and say that your elections are also compromised, so that, you know, it's seen as though this was a bigger issue than it was at that point. So again, it's going to be decided on a case-to-case basis. But then in the event there's this what we call precedence, in the event that the decision can also still be looked at by the other courts and say, based on what the judgment of the Supreme Court stated, or even in the 2013, or even the decisions that have come from other jurisdictions on matters of law, that indeed they could still borrow from that judgment to apply to their case, but not to have the presidential petition now determine the outcome of the other elected MPs.
Okay. Of course, definitely, whichever decision the Supreme Court gives or makes once this petition is filed, because the NAFA is yet to file, they could file today or tomorrow, which is the deadline. Whichever way this decision goes, it will definitely make precedence moving forward in as far as election petitions, especially the presidential election petitions, are concerned. Time now for a break. When we come back, we'll be joined by Charles Kipkulei. My panel will be growing much bigger, and we'll also be watching that story in as far as the timelines now change for the swearing in of the president. That when Power Breakfast returns.